Hello, everyone. I'm Michelle Lee, a partner in Thompson Hine's International Trade Group. Welcome to our SmarTrade Fundamentals webinar. This is the fifth and final webinar in our five-part series. I'm joined today by Scott Diamond, Senior Legislative and Regulatory Policy Advisor in our group. Today, we'll be addressing the critical aspects of trade remedies and enforcement, including unfair competition from dumping and subsidies, so-called AD/CVD investigations, duty circumvention, the Enforce and Protect Act, EAPA, import surges and unfair imports regarding intellectual property rights, Section 237 investigations. Before we start, I must address a few housekeeping items. First, we are recording today's program and we'll send a link to you within the next few days. Second, the PowerPoint presentation will also be sent to you after the presentation. Third, this presentation is intended for general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of the individual panel members only and do not necessarily reflect the opinions of our panel members, clients, employers, affiliates, or Thompson Hine. The content should not be taken as advice, as those views are for informational purposes only. Fourth, if you have any questions during the webinar, feel free to use the chat box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can, both during the presentation and at the end of the program. If we do not get to your questions, we will follow up after. Fifth, CLE credit for today's webinar is pending. Please be sure to complete the verification of attendance survey. The link to the survey is posted in the chat. We will also paste the link in the chat at the end of the program. I will announce the attendance tracking code at the end of the program. Again, thank you for your interest. Let's get started. So today we will tackling several items within the trade remedies law. The first one will be Section 201 investigations, and then will be followed by the 232 investigation and the notorious 301 investigations. My colleague Scott Diamond will be leading the deep dive on those investigations, and I will discuss the AD and CVD investigations and circumvention with you all. At the end of the program, Scott Diamond will come back in and talk about Section 237 investigations with me. So next slide, please. So what are trade remedies? Broadly speaking, we're talking about many things, including actions in response to unfair competition, where the sales are made at less than their fair value, which we call anti-dumping, AD. Where the imports are being subsidized by foreign government, which we call the countervailing duties and CVD. Then we talk about we will discuss the circumvention of the AD and CVD orders under the Enforce and Protect Act in the AD and CVD segment. And Scott today will discuss Section 201, where the import surges causing or threatening serious injury, and Section 232 under the Trade Expansion Act of 1962, where imports will have impact on national security. Section 201 of the Trade Act of 1974 is about the act or policy practice of a foreign government that violates an international trade agreement that is always unjustified, unreasonable, or discriminatory. The notorious Section 201 tariffs that were aimed against the Chinese imports were one great example of it. At the end, Section 237 of the Tariff Act of 1930 comes in and to curb the unfair imports, which infringe the international property rights and conduct other forms of unfair competition. Next slide, please. What are the general purpose? I will not spend too much time on the purpose of the trade remedies because we will have a deep dive in each of the sessions. But overall, the trade remedies is coming in to help the U.S. industries to have a relief against some unfair imports or something that they cannot deal with themselves, where, for example, the Section 201 safeguard action have to come in and give them a temporary relief. So trade remedies is all about relief that is granted to the U.S. industry to fight against the imports in unfair competition or fair competition manner, which we can discuss in detail in just a moment. Next slide, please. So my colleague Scott Diamond will discuss about the Section 201 investigation in the next slide. Here we go. Scott, will you be able to join us and discuss the Section 201 investigations?
Yes, if everybody can hear me, I'm ready to proceed, although I've had some technical difficulties. Michelle, can you hear me?
Yeah, perfectly.
Okay, well, great. The first three trade remedy actions that we're going to discuss are, in my opinion, a hybrid between being both trade remedy and trade policy tools. The first three we're going to talk can be used for both negotiating purposes by the U.S. government with foreign countries. That would be the policy aspect of it, and that was discussed some in last week's webinar. But they also allow for appropriate actions and relief when necessary. And this first one is import surges and safeguard investigations under Section 201 of the Trade Act of 1974. This law sets forth the authority and procedures for the president to take action by determining if, quote, an article is being imported into the United States in such increased quantities as to be a substantial cause of serious injury or threat thereof to the domestic industry producing an article like or directly competitive with the imported article, end quote. And these bullet points just provide a quick overview of the Section 201 process. These actions are in compliance with our international obligations under both GATT Article 19 as well as the World Trade Organization safeguard agreements. But the key thing to take away from this slide is that global and Section 201 in general is that these global safeguard investigations do not require a finding of unfair trade practices. This is import surges. And the second thing is that any relief that may be provided is temporary. You can move on to the next slide, please. Can we go to the next slide, please?
Scott.
Thank you. While rarely used, the purpose of a 201 safeguard action is to determine if the affected U.S. industry is being seriously injured or threatened with injury, and if so, whether the increase in the imports is a substantial cause. It has to be a substantial cause of that industry. So any petition is going to lay out the problem and the alleged injury, but the petitioner in this instance must also include a plan indicating how to facilitate U.S. industry's positive adjustment to the import condition. The ITC in reviewing these matters must consider both import trends as well as in order to determine injury, they're going to look at things like significant idling of U.S. plants, excuse me, the inability of a significant number of U.S. firms to continue production at a reasonable level of profit, and any significant unemployment or underemployment. If there's an affirmative finding, the ITC considers actions that might address the serious industry and assist the industry in recovery. recommend increased duties on the imports, and tariff rate quota on the product, a modification or imposition of any other restrictions. Upon presenting its report to the president is the sole arbitrator here, so to speak, that decides which, if any, of those recommendations will be implemented. And in most cases, this 201 will result in negotiations with the involved foreign country to seek to address and alleviate the industry. But ultimately, it's to help U.S. industry return to health, and any actions taken are temporary. The one that was up there on the previous screen, the most recent one just this past November, actually just resulted in tariff rate quotas being implemented for 4 years. Now, moving on to investigations under Section 232 of the Trade Expansion Act of 1962. Section 232 allows the president to impose import restriction based on an investigation and determination that certain imports threaten U.S. national security. The law allows any department, agency, head, or any interested party to request that Commerce investigate this. And once received, Commerce turns it over to the Bureau of Industry and Security to conduct a formal investigation. And obviously, since this is national security related, Commerce will consult the Department of Defense as well as any other agencies deemed necessary. And what they're considering here is on the last bullet point on the previous slide, is they'll consider existing domestic production, future capacity needs, manpower, raw materials, production equipment, and other growth requirements or any other relevant factors. Like Section 201, this trade remedy tool has rarely been used. Before the Trump administration, the president had last imposed tariffs or any other trade restrictions in 1986. Of the investigations undertaken since 2017, only 2, steel and aluminum, have resulted in any tariffs or tariff rate quotas. In the other investigations, Commerce concluded that there was a national security threat, but there was no formal presidential action. Instead, things like working groups were established, a monitoring system was established, or in a couple instances, no threat was found at all. As for the steel and aluminum, there are tariff rate quotas against numerous countries for that. And as a result, BIS implemented a product exclusion process that allows impacted U.S. domestic industry to seek an exclusion from those tariffs for imports of steel if they can't obtain it as third parties into the person aren't in place. The issue with that is that it is company specific and very product specific to just that applicant that's seeking the exclusion. And it's getting increasingly difficult to obtain one because U.S. domestic industry or any interested party actually has the right to object to that. And with these being in place for so many years now, the argument is that a U.S. domestic industry should have been able to find another source where the tariffs would not be applied. Now, moving on to the next slide, we'll discuss investigations for unjustified, unreasonable, or discriminatory trade actions under Section 301 of the Trade Act of 1974. Section 301 grants the Office of the U.S. Trade Representative, or USTR, a range of responsibilities and authorities. And this includes the right to enforce U.S. rights under trade agreements and respond to certain foreign trade practices. The statute allows the U.S. to impose trade sanctions on foreign countries that violate either trade agreements or engage in what is stated here, unjustified, unreasonable, or discriminatory trade actions. Historically, it's been used to pressure other countries to eliminate trade barriers and open their markets, so again, touching upon trade policy. But there is an investigative process to it. And on the next couple slides, I'll walk you quickly through that. Upon initiating an investigation, the USTR must request consultations with foreign government regarding the issue raised. Following those consultations, which typically don't produce any fruit, the USTR then begins its investigation by holding a hearing that is held by the Section 301 committee, and public comment is sought. And any final determination under Section 301 has to occur within a year. And although this has become a well-known tool because of China, historically it's only been used 130 times since 1974, and only 35 times since the creation of the World Trade Organization in 1995. And of those 35, the bulk of those are really believed to have been used primarily to build evidentiary cases and pursue negotiations and dispute settlement at the WTO. However, the first Trump administration kind of changed the trajectory of Section 301, and they initiated 6 investigations. However, only 2 resulted in retaliatory actions. The first one, the well-known one, is China for their forced technology transfer and intellectual property infringement. The second one being with the European Union and their provision of subsidies on large civil aircraft. Now, on the next slide, I'll speak directly to the China Section 301 investigation and those resulting tariffs. In this investigation, China's intellectual property rights practices were found to be unreasonable and a burden on U.S. commerce. And upon issuing that affirmative determination in 2018, additional tariffs were implemented in the range of 2.5% to 25% on approximately $500 billion worth of U.S. imports from China. As you can assume, as it made the press, China retaliated, and thus those tensions remain. Under mandatory statutory language, Section 301 requires a 4-year review that just concluded this past May. And not only were the existing duties kept in place, but the Biden administration implemented tariffs on additional industry sectors, including semiconductors, electric cars, certain batteries, solar cells, maritime cranes, and certain medical products. So obviously, at $500 billion worth of imports, this action has clearly impacted U.S. supply chains. So very quickly, similarly, there used to be an exclusion process for Section 301 when a affected U.S. party could not obtain what they needed from a source other than China. However, the bulk of those have expired, and there's only very limited ones since October for certain machinery from China used in domestic manufacturing. And with that, I will turn it back over to Michelle to begin addressing anti-dumping and countervailing duty issues.
Thank you, Scott. That was a very comprehensive rundown about all the 3 different investigations: Section 201, Section 232, and Section 301. And I've seen some comments that the presentation were not available on the screen. Don't worry, we will send and provide the presentation, the slides, after the program. So next, we will go and talk about the anti-dumping and countervailing duty investigations. So in the Title 7 of the Tariff Act of 1930 addresses unfair pricing and competition by foreign companies and governments, including the sales at less than fair value and subsidy countervailing duties. And before I delve into all these weeds, I would like to give you a simple example what trade remedies, what AD/CVDs are for. Imagine there is a small US-owned company called Baby Shop that manufactures and sells baby supplies across the United States, and it had been doing well for many, many years. And suddenly it found out that it was not selling as well as it used to be. Even after lowering their prices, it could not help their sales. And they found out through their customers that the customers started to buy from a foreign company that sell their products far below this baby shop's prices, and also below any of their other competitors, like U.S. competitors, other U.S. baby supply store. So the foreign company can sell at such low prices because they receive some below market loans through the subsidies from the foreign government, which enable them to sell their products at unreasonably cheap prices. And the U.S. baby producers, the baby shop, cannot compete with this unfairly subsidized imports. This pretty much eliminates all other U.S. competitors as well. And so pretty soon the foreign company gets the full discretion at the price, market pricing. So these kinds of market distortions are what the AD and CVD investigation aim to address. We love, everybody loves free and fair trade, which is good for everybody. It kind of, fosters healthy competition, create jobs, and, it's a driving force of the global economy. But when we talk about market distortion or illegal trade practices such as dumping at less than their fair value, their cost of productions, or, selling imports into the United States through an unreasonable cheap price because of the subsidies, those market distortions basically eliminate the market competition at the expense of the U.S. workers and industries. And that's where the Tariff Act of 1930, Title VII, is trying to address. So dumping and subsidy margins will, if found affirmative by the Department of Commerce International Trade Administration, let's call it ITA, then will lead to additional tariffs after the ITC, the International Trade Commission, come in separately and determine the U.S. industry is suffering material injury. Then there is a AD or CVD and or CVD order, basically that imposes additional tariffs based on Commerce ITA's determination on the dumping and subsidy margins. And next slide, please. So I would like to first introduce you what AD duties means, what dumping at less than fair value means. In my example, I did not address this scenario, but if it takes my baby house example, that's where the foreign company are selling at unreasonable cheap prices that is even lower than the foreign company sells in its own home market, the foreign home market, the foreign country that where it manufactures the products, which we call the home market, or it sells below the prices where they sell in the third country, where they sell more than 5% of their products. Or it's even lower than the constructed value, which we call basically the cost of their production. So when that occurs, Commerce will find that a dumping occurs, and they will find a margin based on the difference between the price or cost of the foreign company sells in its own foreign market or third country market, or by its cost, and the price they sell in the US market. So it's a very easy, sounds very complicated, but it's a very easy kind of equation. You take the price that they sell in their home country and the price that they sell in the United States typically, and you see a positive difference, then that is where dumping happens. And dumping is unfair when it causes injury to or threatens to injure US industry that manufactures the same or similar goods. Dumping would not matter if there's no injury. And whereas the injury, in my baby house example, you will see the baby house starting to, even by lowering their price, they cannot catch up their sales. They are losing revenues. Their production number go down. Their market share dwindled. Their prices just never will be lower than the competing imports. There are more and more unemployments, laid offs, and they might even bankrupt. All those not so great performances of the baby shop, the US-owned businesses, will be a indicia of injury. And foreign producers often dump to gain a greater market share in the first place and then build their brand recognition later. So that's why we want to curb dumping. This is an unfair market distortion practices. Next slide, please. And CVD duties, I gave you the example in the baby house example where it comes in where a foreign government subsidizes their industries by providing financial assistance to benefit the production or exportation of the goods. Subsidy can take many forms, including direct cash payments, credits against taxes, provision of loans at terms that do not reflect market rates, provision of goods less than adequate remuneration. Like dumping, this is also unfair when it causes injury or threatens to injure the US industry that manufactures the same or similar goods. However, the unfair subsidies must also be specific, meaning the subsidy practices are aiming to assist a certain group of enterprises, entities, or regions, or it is contingent upon export or import substitution. Next slide, please. So US industry can file petition by itself along the, alleging that alleging all this market distorting practices and requesting for relief for imports that are sold in the United States at less than fair value or dumped, or which benefit from the subsidies provided through the foreign government programs. And after, if there is sufficient support of domestic U.S. interested party, which can be the manufacturer, the trade association, and once you pass the threshold of the domestic support threshold, that the Commerce reviews the petition and will typically issue some questionnaires to both sides or to the domestic party, the petitioner seeking some information, and then we initiate the investigation or decide to deny the petition. Chances are Commerce will highly likely initiate investigation based on its track record of the past 5 years. So once the investigation be initiated, Commerce's ITA division would determine whether the dumping or subsidizing exists, and if so, what's the margin of the dumping and the amount of subsidy. And the ITC, like I previously quickly mentioned, will come in separately determines whether there is a material injury or threat of material injury to the domestic industry by reason of the dumped or subsidized imports. Generally, an investigation would take approximately 300 days for AD investigation or 230 days for CVD investigation, unless it's extended, which we will show you the timeline in the last few slides. Next slide, please. And looking at this timeline of the AD investigation, starting from the day one, from where the petition has been submitted, we're looking at, unless it's extended, we're looking at 287 days, roughly 300 days to finish an AD investigation. And you can see here that it takes around 20 days for Department of Commerce to initiate the petition. And the International Trade Commission will have 45 days from the date of petition to decide whether there is affirmative preliminary injury determination based on the record they collected from all the foreign manufacturers, domestic manufacturers, and the US importers. And it's a relatively low bar. And then Commerce will come in to make a preliminary determination, collecting all the information about the sales, the cost, and decide whether there is a dumping margin there. And then Commerce later will make a final determination. You can see here, it's a two agencies dancing kind of exercise. So each agencies, if turn in a negative determination, the investigation terminates. the other agency will only come in to do its job after the first agency make an affirmative determination. So it's kind of two-party dancing game here, and then once Commerce make a affirmative final determination, ITC will come back in and decide whether there is truly a material injury. At this point, the standard will be a little bit higher based on substantial evidence standard. And then if ITC and Commerce both agree and make a positive determination, one on the dumping margin, one on the injury, then there will be an order issued by Commerce on the additional tariffs. All these imports that falling into the scope of the investigation will have to pay additional tariff. We'll have to pay. The next slides, a couple of slides later, we'll talk about the impact, how that relief is coming into effect. Next slide, please. This slide is just talking about the CVD version of the investigation. It's relatively similar to the AD investigation, except the timeline is shorter, and you will see same time for initiation, 20 days or so, 45 days for ITC to make a preliminary injury determination, then a shorter time for Commerce to make a determination on the subsidies and subsidies margins. And once there is a positive, if Commerce say, look, I don't see there is a margin, and then turns out a negative preliminary determination, Commerce can continue to do the final determination though, and then because party can come in and make their brief, and then if Commerce still say, look, I really think there is no margin of final determination, this is going to be the same in the AD case, and then Commerce say, well, look, I really think there is nothing, then ITC will not come in and will not bother doing its final injury determination. However, if Commerce decide there is a affirmative margin based on the subsidies that the foreign manufacturer gets, then ITC will come back in and say, look, I need to really see whether this subsidies or anything that the imports coming in at the prices, would they be injuring the US parties. And then, and I will talk about when if there is a affirmative preliminary determination comes in, you don't need to wait until the end of it to see the chilling effect, because under the AD and CVD trade remedy laws, once Commerce issues a affirmative preliminary determination, whatever that margin is in the preliminary subsidy or the dumping margins, those will be the cash deposit rates that all the importers have to pay upon the publication of the Commerce preliminary determination. So even though you don't come in all the way to the end, you will starting to feel the chilling effect of the AD and CVD laws. Next slide, please. So as I said, once an affirmative AD or CVD preliminary determination is issued, Customs is instructed to collect the cash deposit rate for estimated duties on all entries of the subject merchandise. And remember, in the two slides that we just walked through, the CVD investigation is shorter than the AD investigation, and folks tend to file petitions on both together because we're talking about same imports. Chances are they are both dumping and getting some subsidy at the same time. So you will see a hand-in-hand two investigations, one on AD, one on CVD, addressing same 3 years of imports in the ITC injury cases, and seeing all the imports surge at the same time, and Commerce just come in and examine different practices and looking at their prices or their subsidy that the foreign manufacturers receive from the foreign governments. And because the CVD comes in earlier, the prelim determination comes in earlier, the cash deposit rate of the CVD side will come in earlier, then the AD side will come in. However, the cash deposit rates based on the Commerce preliminary determination are provisional, are temporary. They can only stay there for 4 months. So when investigation is extended, especially AD side, and then the CVD side may or may not have been extended, you will see that the CVD provisional measures of the cash deposit rate already expired, and then the AD side hasn't come in. Then there is a gap period where the imports can have a free breathing time. That's very interesting kind of practice in the AD and CVD investigations. Once the ITC makes a final injury determination, everything has ended in the investigation, then there will be an order coming out. It can be either AD and or a CVD order, depending what the Commerce found. I'm talking about a situation where a domestic industry have filed AD and CVD petitions at the same time on the same imports. And once that happens, each year after issuance of a AD or CVD order, an interested party may request an amendment review of the duty rates in effect. It could be the petitioner asking for a review for many importers or exporters that they found, or it could be an importer or an exporter who wanted to ask a review for themselves because the exporter or manufacturer, because they think their rates have changed, it should be lowered, and so on and so on. So either side can request a review of the duty rates. Such a review would determine if the dumping or subsidy margin should be adjusted, and also would set a prospective cash deposit rate for the imports coming in. And once the order be issued, every 5 years, Commerce and ITC will come in to do a sunset review to determine whether the order should be stayed or revoked, because depending on whether you will lead to recur dumping or subsidization. Next slide, please. And we talked about administrative sunset reviews already. Administrative reviews aim to ensure that the applicable dumping and countervailing duty rate is correct. So it can be recalculated if the amount of dumping and unfair subsidization has changed. That's why both sides have opportunity to request review. It typically takes 12 to 18 months to complete, and the interested party can continue to ask for review every year during the anniversary month after an AD or CVD order was issued. Sunset review, like I said, happens every once in 5 years. It is statutorily required to determine whether the AD or CVD order should be kept or revoked. Next slide, please. And then we can talk about the AD and CVD order circumvention. But before I do that, I often had these questions. People will ask me, if I want to import, how can I decide or determine whether my imports are subject to any AD or CVD duties? I will say that there is, in each scope of the AD or CVD investigation, there is some HTS harmonized tariff schedule code classification will be provided for the convenience of the importers to decide whether AD or CVD duties have been imposed on the imports that you are bringing into the United States. Those HTS classification are only for your convenience. They are not dispositive. The scope description itself is dispositive, and that will really help you to determine whether your imports are falling into the scope of those investigations and reviews, whether they are subject to the AD and CVD duties. And I will talk about the scope review. If you ever have a question whether your imports should fall into the scope, in the next few slides. And now we can talk about AD and CVD order circumvention. What is this about? Next slide, please. This is when you get an order and then people starting to evade the existing order or the alter to avoid to having paid the additional duty. So a lot of times people ask, now what? I got the order, but now what? Because people are starting to circumvent and taking advantage, evading the existing order. Now, circumvention may take many forms, including completing or assembling some of the components in a third country, or transshipment through a third country and claiming the country as the country of origin, or attempting to modify the product in a minor respect. So, and it can be, next slide, please. It can be, a party can request a circumvention inquiry at commerce based on what they have seen, and all commerce can self-initiate it. The impact, if commerce ever issues an affirmative final determination, would be massive, because products will be either reaffirmed that they should fall within the scope of the AD&CVD order and duty should be levied, or the duty rates can suddenly be broadened on a countrywide basis, or maybe even applied to a third country where the circumvention was attempted. And what happens is that if commerce find out there is a circumvention, they will typically issue a certification provision in the order, and basically requiring the importers to ensure that the import is not circumventing. And it will also clarify about some of the scope language, whether some merchandise should or should not be included. And this tend to be overlapping with the scope inquiry that I'm going to discuss in the next slides. But going back, talk about circumvention. Circumvention can happen in so many forms, and we discussed that there are forms that, where mostly it's completed or assembled in the United States or another country from the parts and components that is subject to the AD&CVD order, and also, or maybe there is some form appearance with the order in the minor respects. There's limitation though. Once a circumvention inquiry is initiated, commerce will not just say, okay, this is bad. They instead will select some foreign manufacturers and exporters and issue questionnaires, just like in the investigation, just like in the administrative reviews. They will do so. They will issue a preliminary and final determination within 150 and 300 days, unless extended. So once the products are found to be circumventing, those products, immediately will be in the scope, and then you suddenly will have an idea that, oh, okay, I don't know that this is a circumvention, but do I need to pay the duties? Yes, as an importer, you will always need to pay the duties, even if you don't know there is circumvention happening. And we can discuss that in the next couple of slides. Next slide, please. And this is where the scope ruling comes into play. For each AD&CVD order, like I said, there is a scope, which is a narrative description that defines what merchandise shall be covered by the order. This is known as the scope. And one limitation to scope inquiries is that they typically only reserve for products that are the same class or kind of merchandise covered by the order. But if you submit a request for scope ruling, because you do want to know whether your products fall into the AD&CVD order, because you don't want to get on the circumvention ruling or get the cash deposit rate there, or a unpleasant surprise there, you can you file this scope ruling, which will address whether your product is in scope of AD or CVD order. It typically can be resolved within 120 days after it has been initiated, and you can file a request yourself, or commerce can do a self-initiation. It could happen together with an administrative review, where a party requests a review of its cash deposit rate that get out from the investigation. Obviously, it will clarify what merchandise is covered by the scope, but itself, the scope ruling itself does not modify the scope description of the order and not supposed to modify the scope order either, unless there is a very compelling circumstance, which is rarely happened. Next slide, please. But even we have this circumvention inquiry proceeding and the scope ruling proceeding at Congress decided that wasn't sufficient. So Congress passed the Enforce and Protect Act in February 2016 as a part of the Trade Facilitation and Trade Enforcement Act of 2015. It established some procedures for an interested party to submit allegation that importer is evading the payment of the AD and CVD duties, and Customs has implemented a thorough process that follows strict timelines, issuance a lot of determination to evasion within just 300 days. Next slide, please. EAPA allegation is slightly different in the sense that it targets evasion, and so it is only targeting the importer. Who can file this EAPA allegation? It can be any interested party, which may be a foreign manufacturer, producer, exporter, or any importer of the covered merchandise who want to challenge its competitor, another importer, and saying, look, that importer has unfairly evading the duties, whereas I am not. Of course, the focus is on the importer who is violating the order. So just being an importer doesn't mean you have to kind of share everything that you are doing under the sun. But an importer definitely can file a allegation against a competitor as well. And it could be a trade business association where the majority members are producers, exporters, or importers. Or you can be a U.S. manufacturer, producer, wholesaler of a domestic live product, which is just the similar products. Next slide, please. So the timeline here, as I mentioned, most of determination issued within 300 calendar days. Here, if you're looking at the day one as the initiation of the investigation, there is a 300 days calendar timeline unless it's extended to 360 days if custom considers it's extraordinarily complicated. And when would custom initiate investigation? It is typically 15 days after allegation has been filed, 15 business days. From there, CBP has 90 calendar days to make a formal decision on whether there is a reasonable suspicion that AD CVD duties have been evaded. And then after that, if there is so to be clear that the initiation standard is whether the allegation reasonably suggests there is evasion. And after the initiation, CBP will decide whether they should impose interim measures based on reasonable suspicion standard, which is slightly higher than the initiation standard. However, guidance is not so clear what that standard really means. But generally, CBP will make a decision on the interim measures based on the evidence in the allegation and based on information it obtained itself through, such as a issuance of CF-28s or based on its own research. And then parties may be allowed to submit factual information and written arguments and counter arguments. And then along that timeline, among 300 calendar days, it will make a final determination as to whether evasion happens based on substantial evidence, which is not a very high standard, but it's higher than reasonable suspicion. That is really apparent. And then the scope of the investigation usually covers entries 1 year prior to the initiation through the pendency of the investigation. Next slide, please. what is the purpose of EAPA? What is the difference between it and commerce circumvention proceeding? It will create a multi-party proceeding with greater information sharing and transparency. It will kind of force CBP to follow a strict timeline. It gives CBP tools to investigate allegations and authorize, the collection of information by the party. And CBP has the tools that commerce doesn't have. For example, you can issue a CF-28 to get the information that commerce will not be able to get. And it can allow the parties to contest the determination as in the commerce investigation. Next slide, please. I know that we've been taking a lot of time on the EAPA allegations, and I would like to kind of fly up a little bit so that we have some time to talk about the Section 227 investigation. So the allegation typically will identify the party and then who's the violating importer, what is the AD and CVD orders that you want to target, what is the issue, what is the scheme, and provide all the supporting documentation. Next slide, please. Next slide, please. Thank you. And we talked about what is the standards of reasonable suspicion. So we can quickly talk about next slide. So it's important to know that if a party filing the allegation and the importer or the foreign producer, exporter just doesn't want to cooperate, like customs will have a tool called adverse inferences, and basically relying on any facts that are adverse to the importer, the alleged violating importer, to make a determination. So as commerce will have the same tool for its circumvention inquiry and its investigation, AD and CVD investigation, its MM review. This adverse inferences tool is really powerful because it will forces the importer or the respondents to really cooperate and provide the information. If not, then the importer will be held responsible for the AD CVD duties, even if it were not unaware of any evasion, because the importer record will be the ultimate party who is supposed to be taking the care of all the imports. Now today, most of the investigation involved the transshipment for some countries to evade duty payments, where or the merchandise just undergoes only minimal processing or transformation. Next slide, please. And the interim measures after 90 days upon the initiation of the EAPA investigation, CBP can take some interim measures, which may include suspension of liquidation, extending the period for liquidation, or other actions that are necessary to protect the revenue of the United States, including requiring a bond, additional security, or a cash deposit for future entries. Next slide, please. Finally, if it gets to the final determination, if the evasion is supported by substantial evidence, then it will continue to enforce the interim measures and will talk to the commerce and asking what is the appropriate applicable AD/CVD assessment rate or cash deposit rate, and will assess the duties consistent with commerce instructions. If, however, there is a negative determination, such interim measures will stop being implemented. Next slide, please. EAPA investigation has been very powerful tool for customs to enforce AD and CVD orders. Customs so far has initiated more than 300 investigations, identified over $1 billion in duties owed to the United States, and conducted 45 specific foreign on-site visits or verifications. Next slide, please. Next, we will talk about Section 227 investigations. I know we are running out of time, and Scott, but it's okay that we run over maybe 5 or 10 minutes. And the checking code will be provided at the end of the
Yeah, I think it's clear we're going to run over a little bit. Our apologies for that, but I'll try to go through Section 337 quickly. Under Section 337, the U.S. International Trade Commission, ITC, which we've been referencing, conducts investigations into allegations of certain unfair practices in import trade. And while we haven't mentioned it before, the ITC, so you know, is an independent, nonpartisan agency led by 6 commissioners who are appointed by the president and confirmed by the Senate. Section 337, if you take nothing else out of this, there are 2 things I would like you to remember. One, in my opinion, it's the equivalent of civil litigation almost, but it's in front of an administrative agency. And number 2, it can only provide injunctive relief, but no monetary damages. So in many instances, as I'll mention a couple slides from now, an impacted party will file both the 337 complaint as well before the ITC, as well as a case in a U.S. District Court. Section 337 encompasses infringement of patents, copyrights, trademarks, and certain other statutorily defined intellectual property rights. It also extends generally to unfair methods of competition and unfair acts, which include trade secret misappropriation and other non-IP claims. The vast majority of 337 investigations, however, are indeed patent infringement cases. Next slide, please. And this slide shows the types of infringement. Section 337 investigations can declare unlawful any unfair methods of competition and unfair acts in the importation and sale of products in the U.S. where the threat or effect is, number 1, as the slide depicts, to destroy or substantially injure a domestic industry or prevent the establishment of such an industry, or number 2, restrain or monopolize trade and commerce in the U.S. But in all investigations, to come to an affirmative determination, there must be injury or the threat thereof. Next slide, please. This next slide shows 2 key factors that the Commission and the ALJ consider. First one is importation. You would think that would be fairly clear. The infringing articles from a foreign respondent to the complaint must be imported into the United States. And while that does look simple on its face, it can sometimes be challenging for a complainant to determine whether and how those infringing articles are imported, especially if the articles are merely components of another product. Then the next issue is establishing a domestic industry. The IT must find that there is actually a domestic industry, and the manner in which they do that is known as checking for the technical prong, and that would be ensuring that the articles in the U.S. are subject to are practicing the intellectual property. And the second one is the domestic industries, the economic prong, and that covers ensuring that the domestic industry is actually making significant investments in its operations, and that includes plant and equipment, labor or capital, or activities such as investing for engineering, R&D, and patent licensing. Next slide, please. This slide will show that after the injunctive relief that is an option here, a successful affirmative determination by the ALJ provides for either an exclusion order or a cease and desist order. Under an exclusion order, there are 2 types. One can be a general affecting all infringing articles regardless of their source, or the second one can be a limited exclusion order affecting articles originating from a specific company. And the second available remedy, go ahead.
Yeah, go ahead. You are on the second order. I do want to kind of come in and interrupt a little bit and to discuss the difference between the remedies under the AD and CVD investigation and Section 237 investigation after Scott is done? Because I get that question a lot.
Okay. Okay. Yeah. Yeah, but a cease and desist order is the other available remedy, and that directs the foreign respondent to cease its unfair acts, including selling any infringing imported product out of its existing inventory. And in those situations, since the product is already in the United States, that can be enforced by issuing civil, I believe it's customs would issue civil fines if a party attempts to release such infringing articles from their existing order. The next slide essentially just gives you a summary of the exclusion order process. So what I really want to note here is, while a remedy can be, injury can be found and a remedy can be issued or recommended, there are instances in which the ITC will refrain from issuing the remedy. First, the ITC can either tailor its results or refrain from issuing a remedy based on public interest factors involving public health, welfare, and competitive conditions in the U.S. And the second one is that any final determination and proposed remedial order will go before the president, and he or she will have 60 days to disprove them for policy reasons. However, that is rarely the case. And it's actually rare that public health and welfare issues would prevent the ITC from issuing a remedy. There's been one very recently involving a patent where it was so embedded in so many products that it would have had a massive economic impact. And there have been some for medical purposes, like burn beds, is one of the original 337 cases my mentor handled, where there was injury, but there wasn't sufficient U.S. production, so they took a pass on that one. Next slide, please.
Scott, before you move on, I want to quickly come in and kind of comment on what's the difference about AD and CVD investigation and Section 237. Because when you are facing unfair imports, what can you do? What tools you will have? This is a question that I got asked a lot. And one of the critical difference between AD and CVD and Section 237 investigation, as Scott had mentioned, like what's the causes that you can allege. Putting the causes aside, the remedies are vastly different. For AD and CVD investigations, you will see the in-scope products of the entire country, where the investigation will be initiated and targeting will be the additional tariff will be imposed on all the products within scope of the entire country, where the order is imposing against. Where Section 237 investigation, you basically exclude all the products of the violating actor, or if it's a general exclusion order, all the products that are in scope from coming into the United States. So there will not be any additional tariffs on the competing imports. It will be injunctive relief, meaning that you will not get any monetary damages by filing this investigation against those so-called bad actors, but you can basically keep all those competing imports out of the country of the particular actor or entire investigation, depending whether you can get a general exclusion order or not, like Scott just said. So thank you, Scott, for pausing. Let's move on.
No. This slide just talks about the process, and like I started off, the 337 process is litigation. It's just in front of an administrative judge as opposed to a U.S. district court, so it flows very similar. The main differences would be that before the investigation is initiated, there's a public comment period where the ITC seeks input. And in addition to there being the U.S. domestic complainant and the foreign respondent or respondents, The ITC's Office of Unfair Import Investigation is also enters its appearance and represents the public interest. But like the other ones, they're governing rules and procedures, they're protective orders, given the sensitive natures of patent claims and everything. And they conduct fact and expert discovery, have document discovery and exchanges. But as you'll see, the key here, and this is why the U.S. parties will often use this, is that it's on an extremely accelerated time path. So go to the next slide, please. The ALJ in these investigations is typically an expert with experience in IP matters, and it's that individual that presides over the investigation, settles any disputes, conducts the hearings, and issues the initial determination that will go to the full commission for its consideration. The ALJ has to set a date for the final determination. That it's supposed to be more than 16 months. But the full commission can provide an exception to that. And in fact, most often these days they do. And typically these investigations are still running 18 months, but that's a lot less time than you would in a U.S. District Court case. Once the ALJ issues its initial determination, it goes before the full commission for its consideration and review. It has the authority to affirm, modify, reverse even, which is rare, or remand part of it for further consideration. And once a final determination is arrived at, it is then sent to the president, who has the authority to disapprove any final determination for policy reasons. But again, as I stated, that's very rare. And the final part is that if any party is not satisfied with the outcome, it can be appealed to the U.S. Court of Appeals for the Federal Circuit. Next slide, please. There are two, I want to quickly just touch on these. There are two parallel actions that either the complainant or respondent will often take in a 337. They'll file and have a 337 investigation initiated because of the quick timeline and because they want the hopeful injunctive relief, keep these products out of the United States. But they will also, the complainant, the U.S. domestic industry reps, will often also file a parallel action at or about the same time in U.S. District Court. And the reason there is because they can get monetary damages there. However, respondents can counter in U.S. District Court and request to stay of that proceeding on any of the issues that are raised that are the same issues as in the ITC investigation. And that, if granted, that would remain in place until the conclusion of the ITC investigation and the issuance of a determination. The second one is in favor of the foreign respondents. They can actually, in addition to responding and challenging the validity of an asserted patent during the 337 investigation, they can now, starting as of 2022, file before the U.S. Patent Trial and Appeal Board. And prior to 2022, PATB would defer, in essence, on their end, stay such proceeding given the 337, but with some reform in that area, they can no longer stay those actions. They have to consider them. Next slide, please. This slide just gives you some trends. As you can see very clearly, the 337 caseload has increased dramatically in the past 2 decades. As you see in 2002, there were 17 337. And as of 2023, the most recent data I was able to find, there are 107. And they keep the ALJs quite busy, hence the trend up and how long time it takes. And again, majority in the investigations were in patent IP infringement realm, and they're becoming more complex. And I think the reason there might be because ALD, and so now they're involved in computers, telecommunication devices, medical devices. And I think you're only going to see in the coming years continued use of Section 337, because I think domestic industry has realized, no, we can't get our monetary damages right away, but we can use this unfair trade import tool to at least keep the product out of the United States until we can hopefully get monetary damages on the U.S. District Court side. And that's it for 337.
Yeah, thank you everyone for overstaying, staying at the webinar. I'm sorry that we ran out of time a little bit. Again, thank you for your interest in attending today's webinar. If you are not currently receiving our updates and invitations, please go to Thompson Hine and register. Thompson Hine website and register to receive our mailings and under the publication tab. I also encourage you to visit our blog at thompsonhinesmarttrade.com, and our presentation will be shared on our website, and so as this recorded video. And thank you for your interest in attending today's webinar. Enjoy the rest of your day. Thank you.